experience on appellate work and those who are very familiar with the process. Now, to get to know the audience a little bit better, I would like to launch a poll. And so please answer these two questions. We want to know your role and how familiar are you with the appellate review process. So far, 43 people joined the CLE, and we have about 48% of participant responses. Okay, we still have a few folks that need to answer the poll. Okay, 10 more seconds. Please answer these two questions. What is your role and how familiar are you with the appellate process? Okay, 80% of people responded. So I'm going to go ahead and end the poll. Oh, we're at 90%. Okay. So Chuck, as you can see, most of our audience is attorneys that are in private practice, and we have obviously also a few government attorneys and nonprofit attorneys. We have also a few judges and a few court staff members. And I'm glad to see that there's still members of the public and corporate law attorneys. Well, let's get started. First, I'll be sending an email with the presentation materials and the certificate of attendance to those who completed the full 60 minutes this evening. And so in the past, I've heard from attendees that maybe they don't get the email. If you don't get the email, just please check your spam folder. And also you may contact me. I put in my email address on the chat. So if you don't receive the email, please email me directly. My email address is edith@arkansasjustice.org. That's for the certificate of attendance. Also in that email, we'll be emailing you all the materials, and I'll put also in the chat I have put already earlier the email address where you can contact Chuck if you have any questions or are interested on joining the appellate Arkansas Pro Bono Appeals Pilot Program. Also, as the moderator, I'll be monitoring the chat. And so please, if you have any questions, put them there and I'll be able to raise them at the very end. We'll reserve 5 minutes at the end of the presentation. To get started, please allow me to introduce our presenter, Chuck Munson. Chuck has been an attorney for the Arkansas Supreme Court Clerk's Office since July of 2021. He graduated the University of Arkansas School of Law with a JD in 2006 and an LLM in 2007. For the first 2 years of his career, he worked for the Montana Legal Services Association, representing low-income Montanans in consumer law cases. From 2009 to 2021, he worked for 3 Montana attorneys general, representing the citizens of Montana in consumer protection, agriculture, and antitrust matters. He was an adjunct professor at the University of Montana School of Law from 2016 to 2019. Chuck was born and raised in Arkansas and moved back to Arkansas in July of 2021 to work with the Arkansas Supreme Court's Clerk's Office and to be closer to his family. He's currently a facilitator for the Montana Domestic Violence Fatality Review Commission, and he's licensed to practice law in Arkansas and Montana. So now, without further ado, here's our presenter, Chuck Munson. Chuck, I'll leave you the mic.
Thank you, Edith. You hear me well? Great. So thanks everybody for showing up on a Friday afternoon. I'm going to jump right into it because I have a lot to cover. Today's training, it is meant to be a basic training. I'm not going to be giving you a training on what kind of arguments you should make. I'm not going to talk about oral advocacy methods, and I'm just going to briefly touch upon a couple topics that one might consider like advanced appellate practice topics. But what this is about, my intention at least, is to teach y'all how to get a case positioned with the appellate court so you can focus on the advocacy and the persuasion that it is you want to do. I kind of hope to remove the noise that might exist around the filing of an appeal for folks without much appellate experience, so that those folks have an easier time putting their clear surgical focus on their legal arguments and putting their best legal foot forward in the case. My slides, as you heard, they're going to be able to be distributed to you. They're kind of wordy. I go a bit against the prevailing wisdom that you're supposed to have PowerPoints that are light on words and heavy on explanation. Hopefully I'm heavy on explanation, but I put in some significant substantive material in these slides so that maybe you can use them as a reference sheet later. If you're the type of person that feels, it's difficult when you see a slide not to read it, maybe just relax that muscle a little bit today and listen. I'm going to be pointing out certain things on the slides, and so I don't want to tell you to ignore them altogether, but do listen up. I'm not going to be tracking them perfectly. I want these for you to have kind of a resource guide for later. But before we get into the main focus of appeals, I did want to briefly talk about a new pro bono appeals program and encourage y'all to consider signing up to potentially do some good through some volunteer opportunities. At the beginning of this summer, the Supreme Court announced in a mid-June per curiam the Arkansas Pro Bono Appeals Pilot. Right now, we are in the volunteer sign-up phase, and we're encouraging people to sign up, and sign up soon if you would. Those who sign up now, though, won't probably see a ton of requests for volunteers because we don't have our referral pipeline fully built yet. We do, however, have an idea of what it might look like, and I want to share that with you. And this is all with some flexibility. We don't want to build too rigid a system here, but we envision being able to refer people who need help on appeals but cannot afford an attorney to an existing hotline for those who seek nonprofit legal services in Arkansas already, where when they go to that hotline, an initial intake and application process can take place. And because of them being ID'd as an Arkansan who needs help and needs help specifically with an appeal, that person ends up getting referred to our volunteer pool that we put together. So now applicants will either be financially eligible for legal aid in Arkansas or they won't. For people that are eligible, we envision we'll shop out to the group of volunteers a summary of the legal situation that applicant find themselves in and ask for a volunteer. So anyone who volunteers to make contact with an applicant like that would be covered by malpractice insurance provided by one of the Arkansas legal services providers. However, for those who are not financially eligible for legal aid in Arkansas, they just won't continue through the same pipeline. Mind you, I don't think this goes without saying, just because somebody's not eligible for legal aid does not mean that they can afford an attorney necessarily. So any attorney out in the world that identifies somebody that they think could benefit from this, and out in our Arkansas world here, you definitely could still take a pro bono appeal whenever you decide to. In fact, since the per curiam was announced, 2 law firms have already stepped up to do just that, and they did it separate and apart from any pipeline that we're trying to build to get people funneled through, an intake process. So if you are in that position, or if you know someone who needs help and you're willing to provide some type of appellate pro bono service, please let us know. We'd be very interested to hear that. Another reminder is that here in Arkansas, you can get up to 3 hours of CLE credit for time you spend on pro bono. I don't know how much of a carrot that is to you, but it is helpful. Hopefully the carrot here is just the help you can offer. But either way, if you're interested in signing up for this, and I hope to have a time at the end too to remind you that we are looking for signups, but please sign up at pro bono appeals at arcourts.gov. But, what is it that you'd be getting into if you signed up now? I want to talk just a little bit more about that before we get into our full slideshow here. We already at our office have a process that pairs indigent criminal case appellants with counsel if they would otherwise already or have otherwise already qualified for public defender help. So it's not criminal cases. It's going to be civil cases. In other states, they narrow it down where their appellate pro bono program is only a certain type of case, like they just do family law that involves a divorce and a parenting plan, or they just do unemployment insurance decision appeals, something like that. We're not going that narrow yet. We're doing civil cases, but civil cases on behalf of people who aren't incarcerated at the time. So you're not obligated to take on a full representation case or one that precedes the full rep if you sign up to volunteer. What we envision the volunteers being willing to do is review the case and then decide to take it or not through the performance of a consultation. And if you do a consultation and then don't end up taking the case, we'd hope that you are willing to provide some form of unbundled legal services to the person. We review that referral and that initial consultation as a big success for us. Now, if it were to proceed to full representation, well, that's gold standard. That's fantastic, but that's not all that this program's about. And a little background on why we review that referral is such a success. And this doesn't just go for our office, who speaks to a lot of pro se litigants all the time. I imagine our colleagues in legal aid offices and at Access to Justice would echo this, but we just talked to a whole lot of people that could benefit from legal advice, are asking for legal advice and don't know where to find it and struggle to get it. They seem to be, frankly, fairly aware that the world doesn't just have free lawyers to throw at them, but they do wish that they could just get more information. And whenever they approach a court employee, it's very difficult for the court employee to provide them the type of advice they want. In fact, that can't happen. We have to just provide them with legal information. So there's sort of a void there, and we're trying to fill it. And remember, here in Arkansas, you can limit the scope of what assistance you provide to people under the limited scope representation rule. And in doing so, you can count the time that you spend on review and counsel and advice as pro bono, even in cases that don't end up proceeding to a full representation case. So like, for instance, you could choose to provide advice on whether there's any merit to an appeal. You can help somebody identify the strengths, notice the weaknesses, and just sort of develop a strategy for their case. You can help them with something that'd be very beneficial for them. Just make sure that they get their appellate record lodged timely. You can help them during the process of organizing a brief. There's different things you can do through this process that would provide a lot of benefit to the people that are in need. With time, we hope that we can build a group of volunteers that are maybe more mentor types, where younger or less experienced lawyers who want to cut their teeth on an appeal, want to get some experience with this program, we'd maybe be able to, once a few mentors are identified, pair them up with somebody who has a lot of appellate experience. So that's something we're looking at. And I think the last thing I'll say before I get into the main crux of the stuff I want to talk about today is that we're going to be building this methodically, and we're not building it slowly, but we are building it carefully so we can figure out, what works and what doesn't. Amongst the states that we surveyed that have good kind of self-sustainable programs, there's a significant and noticeable kind of quality over quantity ethos to it. So we're not looking to just put a bunch of numbers on the board with this. We want to make sure people land in the right place and get good service from it. So now let's jump into the subject matter here. And I'm covering kind of 4 phases today. Going to talk about deciding to appeal and just spending some time on those first steps. I'm going to talk about what at our office I think we see attorneys might have the murkiest time with getting a record filed with us. Going to talk about brief and hopefully take the noise out of brief filing so you can focus on making a great argument. And then if we have time, I'm going to talk about reviewing an appellate court's decision. If we don't get to this because we're running low on time, don't feel like you're shortchanged. The Cliff's Notes to milestone 4 and talking about it is read your opinions very closely and know what they say. I have a few things that I think is more pointers for how to counsel people when they're reading decisions in a case where maybe they represented themselves. And I left out oral argument in these milestones. It's obviously a super important component, especially if you get called to do it. A lawyer feels the importance of wanting to perform well under the spotlight of the appellate courtroom. I'm just not including it here today because though it's a professional topic, there's varying personal approaches to it. I recommend that you might review the archives that we have online of all the previous oral arguments. They're all recorded and archived. Arkansas has some fantastic oral advocates. You know them when you see them, and you should just watch those if you want to maybe poach some of the methods that they have on there. And I'll also say by signing up for this program, this is just a matter of statistics, but any given case might be an attractive case for an oral argument. So case by case, a case you bring might very well end up in oral argument. But if you just pan back and look at the statistics of all the cases that come through this court, most appeals aren't orally argued. And so by signing up to help with this program, you may request in your case that you'd like oral argument, but you're also not signing up necessarily for a trip to the appellate courtroom in Little Rock if you sign up. Quick disclaimers. This isn't legal advice that I'm giving today. These words are my own and they don't represent the position of the office where I work. I'm not covering specific types of appeals. There's nothing that substitutes a thorough reading of the rules. And maybe the last little piece of practical advice I'll give before we get into the subject matter is, though you want to be mindful of the big picture and your intended destination at all times during any legal matter, I do think, and this is a psychological hack, I do think it's helpful with appeals, especially if you're coaching somebody else through them. It becomes less overwhelming if you just encourage them to approach it as taking one stage at a time and sort of checking off the boxes. Because if you take it one stage at a time and you take them in order and you check the boxes of what you need to do, you end up with a case that's submitted and you ultimately end up with a decision. These are the rules I'm going to cite today. I'm going to be talking about the rules of the Supreme Court and Court of Appeals. I'm going to be talking about the Arkansas Rules of Appellate Procedure civil side and the Arkansas Rules of Appellate Procedure criminal side. I think I'll refer to them as the ARAP Civ and ARAP Crim for the rest of the day. Some of my slides exist purely for y'all to use for like future references. This is one of those slides. Let's talk about deciding to appeal, because it is can kind of be an existential kind of question for the case. It's like being at a fork in the road. The overarching question being like, do we keep doing this? Some stuff you might want to talk about with the client is, what are the client's expectations for the case, and what is it that an appeal could actually accomplish for the client, and whether those two things mesh. You'll also want to, especially if you're doing pro bono work, ask if, besides the lack of a fee generating situation, can you afford the time that you took on it? Does that add additional workload stress to you? I can at least can speak from experience on doing a pro bono appeal at a time in my career when I had zero appellate experience, and I did take it on, and the way I would describe the time that it took me is significant but manageable and also totally rewarding. If I get a little chance to talk about my experience taking on an appeal when I didn't know how to do it, I'll do that later. A couple more narrow legal questions from the outset you need to ask and need to know the answer of. And is there an appealable decision? And if so, what appellate court am I going to, the Court of Appeals or Arkansas Supreme Court? Guidance is for whether there's an appealable issue is in ARAP Civ 2, and guidance for what court you should end up in is in Supreme Court Rule 1, 2A and B, and I'm about to go over both of those now. So when you first ask yourself, is there an appealable issue or decision? It's really an important question, because if not, if there's not an appealable issue, you can expect a dismissal, and you wouldn't want to have had done a bunch of front-end work only just to get a dismissal. So let's figure out what are appealable orders here. The way the rule reads, it's ARAP Civ 2. An appeal may be taken from a circuit court to the Arkansas Supreme Court from, and then it's over a dozen matters. I've put here the kind of most often ones, but I'm going to stop and give a little practice pointer right away, because this is something that trips people up right away. It says an appeal may be taken from a circuit court to the Arkansas Supreme Court of these common matters. And people will think automatically they're going to the Supreme Court because of the way that reads, but don't forget to read all the rules. I mean, Rule Civ 1 says whenever the words Supreme Court appear in these rules, the words Court of Appeals shall be substituted in applying the rules in a case in which jurisdiction of the appeal is in the Court of Appeals under Rule 1, 2. So you want to read ARAP Civ 2 in concert with Supreme Court Rule 1, 2. I think that the better way to go about reading this is read this first about if you've got an appealable order, and then check out Rule 1, 2. So I'm going to read this to say an appeal may be taken from a circuit court to the Court of Appeals from, and then the big one, the first one here is final judgments. I think a majority of appeals, definitely in the civil context, are from final judgments, and it may outweigh the rest of these combined. But there's a few other ones that we get some traffic from. Orders, for example, that determine an action and prevent a judgment from which appeal might be taken. So what is that? So think of a bright line example would be like if you had in a case an order that grants a motion for summary judgment as to all parties and all claims in that case, and then pit that against the opposite, an order that denies the motion for summary judgment. Well, that order that denies the motion for summary judgment, the final disposition in this case is yet to come, right? Whereas that first order that granted it as to all parties and claims, that determines the action. So that would be an appealable order. And, you know, there can be all different types of orders that result from a dispositive motion filed in a case. So rather than go over that, it could be its own mini little presentation. Probably would take 20 or 30 minutes. And this is just a little research pointer that whatever case law platform research platform that you use, when you go in and type a search, narrow it to Arkansas cases and type in is an order granting, and then put in whatever the motions for summary judgment, whatever motion you might be interested in, is it, and then put in an appealable final order and ask it that question with the focus on the Arkansas state case law, and it'll spit you out a bunch of cases that'll get you well on your way to doing some very good research so you can answer the question about maybe your particular situation. Moving on, orders that grant or refuse new trials are appealable, orders that strike pleadings. Specific interlocutory orders, the big one that we see at our court are injunctions. Any order that either grants or denies class certification. Here's a situation where an order that does deny a motion to dismiss or motion for summary judgment can be appealable, but that's when the defense was sovereign immunity from some government entity. Any final order awarding custody is appealable, and then, I'm not going deep on criminal stuff today. Usually, it's a sentencing order for criminal cases, but it could be something else like a decision on a motion for a new trial. So now, if one does decide to appeal from one of the decisions we've just covered, how do you get started? Well, you file a notice of appeal, and you learn how to do that by reading ARAP Civ 3 or Crim 2. But whether it's a civil or criminal case, you have 30 days to file a notice of appeal with the clerk of the circuit court that entered the judgment you're appealing. If you find yourself in the position of maybe there's an adversary that filed their notice of appeal first, and you're having to file a cross appeal, the rule says that you have 10 days after the receipt of that first notice of appeal, but in any event, no less than 30 days from the date of the entry of the order. So if it was a particularly ambitious first to file litigant and they filed only 5 or 10 days after the judgment came out, you don't get just 10 days from that. It's 10 days after receipt of it, but also no less than 30 days from the entry of that order. I can explain a little bit about the notice of appeal. And what is it? It's a document that a person files in circuit court. It gets filed where the case was decided, right? It's to notify that court and other parties that you're appealing a decision, and it becomes a necessary part of your record on appeal. It's not a complicated document, but it is absolutely necessary. I think of it kind of like a ticket to an event. Just because you hold a ticket to an event doesn't mean that you know exactly how that event will unfold. But in order to learn, you got to have your ticket to get to the show, and the notice of appeal is your ticket to get to the show. There's certain pieces of information that need to be in a notice of appeal. They're lined out very beautifully for you if you just read closely ARAP Civ 3E. What the court wants to know in a notice of appeal is who's appealing, so specify the parties. What decision or decisions are you appealing, so specify that. They want to know what are the contents of the record. Many people designate an entire record, however, you don't have to. So if you're not doing that, you want to be specific about what portions of the record. If indeed you want to designate court reporter transcripts, this is stuff that was stenographically created, and you want that to be part of the record. The rules want you to state that you've made the order of the transcript already, and that you've made, not paid yet, but made financial arrangements required by that reporter. And then they want to know in a notice of appeal what court you're in. If it's the Arkansas Supreme Court, they want to know what part of the rule provides that jurisdiction. The rules for criminal, on the criminal side, largely track these rules. They don't have a section just like 3E that gives you this nice, almost laundry-like list of what it is that's needed in there, but everything that you need closely tracks civil stuff, and it is all in Rule 2, so just read that closely. But let's talk a little bit about what cases go to which court. I think, again, just the way I think about it is one way to figure out what court you're in is to use the process of deduction. And to do that, ask the first question, what kind of cases is it that goes straight to the Supremes? And if it's not one of them, well, then probably it's Court of Appeals. So the way the rule reads is that all cases shall be filed in the Court of Appeals except the following. And it's cases if there's a decision that interprets or construes the Constitution of Arkansas, if it's a criminal case where the penalty is death or life imprisonment, certain extraordinary writ petitions that are directed to state government officials. Those are kind of their own species, but they are appealed to the Supreme Court. Appeals pertaining to elections and election procedures, attorney discipline appeals, judicial discipline and disability appeals. And then a relatively high volume we see are just where the Supreme Court has already been the decider in the case and for whatever reason has maybe remanded the case back to the circuit. More litigation ensued, more appealable decisions came out, they got appealed, and now that case is coming back to the appellate court. Well, that case is going to go back to the court from which it came, which is the Supreme Court in this case. The last one is appeals that are quote unquote required by law to be heard by the Supreme Court. Think of, in this case, if there is a statutory schematic that maybe contemplates a particular administrative law review, ultimately a decision from, say, an ALJ going to the Supreme Court. So if it says that in the statute, it may be in the Supreme Court. I just wanted to give like an asterisk of just be aware on number 8 there that through time, some of these situations have been winnowed down by case law just because of the simple fact that the Court of Appeals didn't yet exist when that statute was created. So be aware of that and maybe do just a little bit of light research if that's one of your cases, so you can make sure you're ending up in the right court. Also, know that any case is subject to reassignment by the Supreme Court, and it's Rule 12B, not A, but 12B, that has the factors that may nudge that reassignment. And so examples of those would be cases with significant federal constitutional issues, or if there's a substantial public interest component to the case, or it's for example a true issue of first impression, something along those lines. A passive message of this slide, though, y'all, is that it's simply the statistical fact that most cases are filed, most appeals get filed with the Court of Appeals, at least first. I'm going to take a moment to just comment on the importance of this next milestone, the lodging of the record with the appellate court. Lawyers, I won't call out lawyers. I'm going to call out myself. I may have, and maybe you can relate to me. I didn't do many appeals, but in the few that I've done, I maybe tended to approach this step as a technical step, and because it's not, to me, in my maybe faulty thinking, this isn't the advocacy part that I pay attention to, and maybe I subconsciously would even lean hard on a paralegal colleague to help me through this or something like that. But I gotta say, working here now, I've taken a completely different perspective on it. Being engaged and careful to get this step correct is absolutely being a good advocate, because if you mess it up, especially in the civil context, it can result in potentially harsh consequences for your client. So I say here, it can be a minefield for appellants. I'm just asking, though, that you don't underestimate the importance of getting it right. I say here to brace yourself for this step, but it's not a message of be fearful or be deterred from doing it. It's just be appropriately careful. If all you are is careful and have your eyes open during this and pay attention, it's not unnecessarily gnarly at all. I've left you here with the slide with some rules that I'm about to go over that they have to do with the timing of the filing of records and the composition of the records. On the civil side, pay close attention to ARAP Civ 5 and 6 and Rule 3.3. And I'm going to go over all this stuff with more substance here in a little bit. And on the crim side, it's Rule 4 and Rule 3.4. And for both of them, when it comes to the record preparation, Rule 3.1, you want to be conversational in this topic just for ease of communication with your colleagues at circuit clerks and court reporters' offices. Truly, though, when it comes to organization of the record, the heavy lift part of it is not on you as attorneys. It's just that where the rub is that the responsibility is on you as attorneys to get this stuff timely filed. So looking at timing considerations for the lodging of a record, civil appeals and criminal appeals, on both sides, the filer gets 90 days from the entry of the notice of appeal for most appeals. Again, there's a little more abbreviated of a timetable if, say, you are appealing the issuance of an injunction. That's embedded in the rule. You can read more on that if you're interested. But most appeals, again, it's 90 days from the entry of the notice of appeal. In this kind of post-pandemic workload world, there have been relatively common extensions given because of the amount of workload that has been put on court reporters. So getting extensions is common, and circuit courts are able to extend out past that 90 days. It's just they have to make certain findings that are in ARAP Civ 5B1, and the appellate courts really want strict compliance when you're asking for an extension. I'm going to read it real here. I have it flagged. So the circuit court can find and can extend time if they make the following findings: that the appellant filed a motion explaining the reasons for the requested extension and served it on counsel of record, The time to file the record hasn't yet expired. The parties have had an opportunity to be heard on the motion, either at a hearing or by responding in writing. The appellant has timely ordered the stenographically reported material and made financial arrangements, and the extension of time is necessary for the court reporter to include that reported material. So you need, you have the ability to get extensions. There is a ceiling on how long you can get it extended out there. In no event shall an extension go more than 7 months from the date of the first notice of appeal. And on the criminal side, it tracks exactly with the civil side, except for that jumping off date for calculating the extension is a little different. And with criminal cases, it's in no event shall an extension go for more than 7 months from the date of the entry of the judgment or order. So civil, it's the date of the notice of appeal. On the criminal side, it's the date of the entry of judgment or order. So that's just a slightly more expedited process there on the criminal side. If somebody, I'm going to talk about getting informal pauper status later, but if somebody has to pay court fees, it's $185 for a lawyer to file an electronic record with us. There's no fee in felony cases, and if it's a pro se filer, they have a $165 fee to file their paper record with us. I want to start talking now about getting you a compliant record. Hopefully, move through this record stuff here quickly. The rules that you read, and I've put them all for you here. Rule 3.1 is the general preparation of a rule. 3.2 is a short rule that just, it is items that are typically excluded. And then 3.3 tells you, and it lists the common items that would be included in a civil record. 3.4 is common items for a criminal record. These are good blueprints, not just for you, but for you to provide to circuit clerks and court reporters if you think it would be helpful for them. I think open communication with those offices is, I say helpful here, but in some cases it's just necessary. And my friendly perspective on this for y'all is to encourage just a little bit of, cordiality. Record preparation, if you think about it, if you know how it's done, they have to put it in just certain shape for the court to want it, the appellate court to want it. And it takes time and resources from them to do it. And so I highly encourage you not just to do this to be a decent person, but I think it will actually benefit you if you approach them with the appropriate respect when you're asking them to organize a record for you. Do be prepared to talk about what you designated. Importantly, be prepared to talk about compliance with the e-filing rules. I'm going to go over some of that stuff with you here in a minute. I'll say, in terms of what you designated and putting it together, circuit clerks' offices are great at that. So you don't have to, worry about that too much. And especially in population centers that might drive a little bit of more litigation, maybe there's more commerce there, whatever the reason that more cases come out of them due to them as population centers. There's certain jurisdictions that are getting almost second nature in being able to put together a nice compliant electronic record. But on that note, in concert with all this friendliness, and especially if you're guiding somebody through this process and they're pro se, it is also fair to be politely firm as your deadline approaches. It's very important to you to get things on time, or you wouldn't be doing it. So, if for no other reason but to have a line of communication open so that you can know and anticipate if an extension is necessary, just be polite, be firm about your deadlines, and keep that line of communication open with those professionals. So what's in a typical civil record? There'll be a cover, and that's created by a circuit clerk. It's not something you create. There'll be a table of contents. Universally, court reporters and circuit clerks call it the index, even though it's not at the end of the document. So get used to that terminology. The operative complaint goes in there. And then from there on out, just, the pleadings that get filed, the answer, and then all subsequent pleadings that get filed. And they want them organized in a way that is chronological hopefully makes intuitive sense to you. It just means in a linear historical pathway by date of the document entered, right? You need your final judgment, decree, or order in there. Not all cases have these, but if it exists in your case, any post-judgment decree, order, or any motion that was after the judgment, and then any order granting or denying that post-judgment motion. Then, of course, we need the notice of appeal. And then please include any extensions. Sometimes people are leaving out extensions and we get a perfect record, but it appears late on its face and we reject it and we're told, oh, no, but I got extensions. Well, if you don't get the extensions in the record and they're not certified, it's kind of as if they don't exist from our office because we didn't know they were there. So do be mindful of getting that. The court reporter's portion has a cover that they make. They do their own index. They then put in the transcript. Any digitized exhibits end up at the end, then they certify that too. That's your basic looking record. I've got a little more to talk about records. Criminal records has the same nice list in Rule 3.4. For the sake of time, I'm not going to go through it. I think if you can visualize what a record looks and feels like, it'll make it much easier on you once you're doing this work. So the product that you're going to end up delivering to us is an electronic file, and it's either 100% or very close to 100% a PDF file, okay? And these PDFs get bifurcated into two parts. One of the parts is the record's pleadings, so that's the court documents, and the other is the record transcript, all right? The PDF that you get has to be word searchable. If it's not, that's fatal to your filing and it has to be rejected and made searchable. The cover page, this is pagination concerns that are under the rule. The cover page on both the record pleadings and record transcript is 1, and then it goes chronologically from there. So the record pleading has its own separate chronological pagination where it starts on page 1. And so does the record transcript. Don't overthink it. It's an easy way to paginate stuff. The record has bookmarks as well. And what a bookmark is it allows a reviewer to open a pane on the left-hand side of the document and be able to very conveniently search the contents of these large files without having to scroll through hundreds or even thousands of pages. I'm going to show you right now. Sorry. I'm going to show you a bookmark. So you see this see this record. This is a cover page. This is where the index is. Say you want to see a document. You just open this up. These are bookmarks over here, and PDF software allows you to put in bookmarks. So let's say, you're looking for something, fairly specific, like the judge is wanting to find this first amended answer. Boom, right there. Instead of scrolling through and waiting to run into it. So it's just an ease and convenience thing for the court. And those bookmarks are placed in there document by document by the circuit clerk's office in a lot of cases. So bookmarks that are compliant with the rules are, quote, to each document in the record, and that's on the pleading side, and at the beginning of each witness's testimony, and that's on the stenographic transcript side. I hope with this slide, I'm earning my keep alone just with this one, because this is some stuff that even knowing the rules really well, you just might not know. I'm showing this to you to show you a perfectly organized multi-volume record uploaded on eFlex that makes records managers at our office happy when they see it because they don't have to go in and do a bunch of work to make it right. You'll note that these files are paginated with the pages that exist in each file. That's actually is required by rule. But the part that's not is how this stuff is just so organized. So first off, you need to do and fill out an appellate court cover sheet and upload it. Appellate court cover sheets can be found right here. You can download it right there. And it's a nice, slick, fillable form that you can use. Please fill it out all the way. Then for your first volume of the record that you're going to put in, choose record lodged. If it's a case where you have to pay a filing fee, choose record lodged with the $ sign and then describe it. If it's a case where you've got a filing fee waived, I'm going to talk more about that later. Choose the record lodge without the $. And then here's the part you just wouldn't know. And so I'm letting you in on it. The rest of the document, just pick the document description multi-part document if you've got a multi-volume record. This is great looking. This picture is something you should keep if nothing else. It'll make your upload experience easier, and then in turn, our folks here will be happy too, and so everybody's just happy with that. Now, let's talk about costs. If you're lodging a record and a pro bono client hasn't been found to be indigent below yet, got some ideas for you, because these records can be expensive. Like typical records are probably in the hundreds of dollars, but for sure we see them in the thousands. If nothing, no portion of the record has been lodged with the appellate court yet, what you should try to do first is pursue a petition to proceed in form of papyrus in the circuit court, and it has to be accompanied by an affidavit in support of the motion. If the circuit court grants that motion, the filer won't have the financial burden of paying the circuit clerk and court reporter. So this is helpful, right? Now, if you're up against a time crunch by the time you're hearing about this and you don't think the circuit court could even entertain it, you can get a much more abbreviated partial record and file it with us and file it contemporaneously with your petition to proceed in form of papyrus and affidavit on behalf of your client. What would be in a partial record? It's going to cost a lot less. What we need is sufficient documents to illustrate jurisdiction. So we would need a final appealable order, the notice of appeal, any filings subsequent to the final appealable order or notice of appeal, and then it needs to be certified by the circuit court. And if you get that certified partial record, you can file it with this stuff. And if you're really up against the wall on what's a ticking clock on your 90-day deadline to file, or any deadline that might exist to file, you may want to file all this stuff with, look at Arkansas Rules of the Supreme Court, Rule 3-5. It's about petitions or certiorari to complete the record, and you may want to file that as well. If you ever run into that situation, you're also welcome to come to our office so we can go over it with you. Now I'm getting into brief stuff. This is the part where you get to use your powers to persuade, and I'm just trying to make sure that it's not stressing you out to get the brief in the right shape, so that the only stress you have is getting the brief into understandable form so that you can be a good advocate. The brief, briefing starts right after the record gets filed. Know that. I mean, you can pat yourself on the back for a minute for achieving the milestone of getting the record filed. You aren't on the downhill slide yet, but you're cresting the hill if you've got your record filed. The brief is scheduled. You have 40 days from the filing of the record. It's then 30 days after the filing of the appellant's brief that the appellee's brief is due. And then the appellant's reply brief is due 15 days after the appellee's brief is e-filed. This is all in Supreme Court Rule 4.4. Now, of course, the nature of modern practice is that lawyers commonly seek, and on some level, almost as commonly receive extensions. It's just eventually, you can't keep asking for extensions. You'll end up with a final extension, and final absolutely means final. There's no clerk discretion if it's a final extension, and if it is on final, the court won't budge either. So if you are in need of an extension for whatever reason, read Rule 4-4H about extensions. When it comes to putting together your brief, I've got some rules here for you. I'm going to just start with the guidance on Rule 4.1 that has to do with formatting and style. Briefs are to be typewritten using word processing software, and they shall be contained in a single electronic file and in Word searchable portable document format. So similar to a record, right? They want the PDF files to be converted from the software from which they're created. They don't want grainy scanned documents to be the PDF. They want something readable, so they want big 14-point font. They want it double spaced. It needs to be paginated consecutively, much the same way as a record, with your cover page being page 1. And then it also, like a record, needs to be bookmarked, and I'll go over the sections that need to be bookmarked here in a second. They don't want any external hyperlinks, even if there's a really great article you want to cite to them or something like that. For cybersecurity purposes, we'd never want a malicious hyperlink to end up in the court system. So if you find yourself really wanting to cite a hyperlink, you need to remove its functionality before you file with us, or the thing will get rejected. So, however it is that you think best to tackle it, and the outlining and development of your brief, go for it. I think we offer a really good service that we can check your brief for compliance before filing. In fact, when the briefing notice goes out upon the filing of your record with the deadline, it has some email addresses, including mine, on there, so that you can email a handful of people in our office to get a really quick turnaround on whether or not you're compliant, and get some peace of mind before you file. Typically, if people do have issues, they're minor, and if they're focused on the brief, they can fix them pretty quick and get in a near perfect brief, which I think is good practice to do. Sometimes people throw stuff at us and just hope we take it. We don't play blocker much, especially if somebody's on a final extension. We think it's more important that briefs get through, but I think it's best to honor and respect the court rules, and give them a brief that is compliant with those court rules. Some of the rules are absolutely necessary. Like, for instance, if you can't word search the brief, it's fatal to the brief. So anyways, the only thing we can't do if you're talking to a pro se filer is, of course, a court can't give guidance on what they ought to be writing. We can just say whether or not the brief that they give us is compliant. So here's the sections really that we look to when we're reviewing a brief. We just basically ensure that they contain the right contents, and that they're up to speed with e-filing rules, and then we file the thing. Please provide a cover page, and your cover page should have your case caption, the case number, the lower court information, the title of the brief, and an attorney info block. Please have a table of contents. Please articulate your points on appeal. Please have a table of authorities. If you're the appellant, you must have a jurisdictional statement where you illustrate the proper jurisdiction in the proper appellate court for your case. They can be as short as a few sentences. They can be, a few pages long. Whatever the case may be, you must cite the record on appeal when you are articulating jurisdiction. Then there's a statement of case and facts. It's not meant to be an argumentative section. It also must have citations to the electronic record on appeal. Then you can make your argument, request your relief, and provide us with a certificate of service and a certificate of compliance. There's some certain things in a paragraph you got to say you complied to, like our word count limitation. There's an administrative order 21 section 9 that says you've scrubbed the brief for any external hyperlinks, and administrative order 19 that concerns certain confidential information not being in your brief. The word count limitations for briefs is 8,600 for appellant's briefs and appellee's briefs, and 2,875 for reply briefs. Very rough estimate. That's about 45 pages, give or take, for appellants and appellee's briefs, and about 15 pages, give or take, for reply briefs. Only count, when you're doing your word count, the jurisdictional statement, the statement of the case and facts, the argument, and the request for relief. That's all you need to count. And then if you want to cite properly, which is important to the court, follow the convention right here. If you're citing your page 11 of your record pleading, this is how you do it. And this is how you do it if you're citing your transcript. We have a software that can go in and find these citations and embed internal hyperlinks before we send these briefs off to judges, where a judge, once they get it, can just click on your citation and go straight to the part in the record that you cite. It's very slick. It's very handy. If you want an oral argument, you need to read Rule 5.1 of the Rules of the Supreme Court. You need to request that oral argument in writing and contemporaneously with the filing of one of your briefs. Again, just in the aggregate, it's statistically unlikely that a case gets orally argued, but if you want to ask for it, you absolutely should. Other than that, once briefs are submitted, your case will get in line and it'll ultimately be decided. It can take several months and sometimes longer. Edith, I made it to the part where I can kind of lop off, but if I can get through maybe a few more comments, were the 5 minutes at the end of the hour or right now for questions?
Does anyone have a question right now? Do people have questions? If so, please put them in the chat. I think since I haven't seen any questions that have been posed on the Q&A or on the chat, I will go ahead and try to go into milestone 4. And then if there's any questions, we may extend it to 5 minutes.
Great. Just a couple things. Like I didn't realize this has to do with kind of who gets in line first with court decisions. So you can kind of start to at least try to anticipate your decision. But under court rules, appeals in criminal cases take precedence over all other business. The next precedence is appeals described that are the interlocutory appeals, the ones in the rule that are injunctions, receiverships, which are rare, and Rule 23 class certification decisions. So these just tend to move with a little bit more velocity than other decisions. When you get an opinion, there's really no substitute for a close reading of that opinion. You may want to read and reread it several times. If your case is affirmed, period, the way to explain that to somebody is that the circuit court decision, it stands as is. But what if there's a reversal? If you're the appellant and you get a reversed and dismissed, that may be reason to celebrate, right? But what if it's reversed and remanded? Well, that may be as good. Maybe you've won the battle though and not the war, and maybe not either. So you just want to read it very closely. Same thing with an affirmed. It's at least possible you could get an affirmed case where you think, if you're the appellant, you took a loss, but it's affirmed as modified, and the modification that got made somehow, maybe it modifies the calculations that were made on a money judgment, or it modifies time served, something like that, and it could inure to the benefit of the client. So again, this is a long way of saying just read these very closely. I think since we're to the end, I'll just summarize that we hope people will sign up for taking appeals. For people without attorneys, it really can be overwhelming, and if you do it, it's honorable. I think if you treat it like a road trip, it's something that psychologically you can kind of get through by just getting through one milestone at a time. And just my 2 cents on this is, having done an appeal, I took one on when I'd never done an appeal before. The experience I had was that the client, there's definitely in the civil case I took an attitude of gratitude, and it was even though I lost, I ended up losing the case. And I took this case from another state's equivalent of a Arkansas District Court to the other state's equivalent of an Arkansas Circuit Court, all the way to the Supreme Court of that state, and I lost the whole way. But even having lost, it was time very well spent. It was an impact case. I think that the judges appreciated that I was doing it pro bono, and appreciated the arguments that were being made. It did clarify some law in that state, enough so that by the time the Supreme Court opinion came down, even though we lost, it got some legislators' attention, and they tried to forward legislation that would help sort of ease the burden that my client had been through under our state's exemption law. It was a collection case where she had her bank account collected on, and it left her completely destitute. So anyways, it was a great experience for me to do that, and it really didn't take me a whole lot of time. And even though we lost, the client was super grateful. And I think it might be the case that it's just a more natural way of things that a client that has their case taken on, and it is a civil case where they don't necessarily have the expectation of counsel, but then they get it. I think they'd be very grateful for that. And that just helps you, gives a little wind into your sail while you're working for them. So please do consider signing up. Here's the email for signing up. It's probonoappeals@arcourts.gov. You won't be committed to take a full representation case, but to please be open to taking time to review these cases and maybe, working on them enough so that you can do a consultation with people and provide some sort of unbundled service for them. You may, if you get into this, you may want to get entered into the legal aids pro bono system, but specify it's for the purposes of this appellate pro bono project, if that's what you want it to be. That is necessary to get the cloak of that malpractice coverage. But also, we'd like you to maybe let us know if the case doesn't go through the nonprofit pipeline that we want to construct, that you let us know anyways. And then the last thing I'll say is, even though don't perceive it as a humble brag if you're working on a case, that in your signature block, when you're working on it for the court, that you know, you don't have to do this, but we think it's perfectly appropriate that you make note that you're pro bono counsel on that. It'll not only help us sort of track people that are doing this, but it's just, you know, a note to the court as well of you know, how you came across this case. So anyhow, Edith, thank you. I'll wait for some questions now.
Yes, thanks to you, Chuck. And I have a question. So I know that you touched on the different choices that attorney may have to volunteer with you with the new program. But when volunteering for Arkansas Pro Bono Pilot Program, can you decide the extent to which you represent a pro bono client?
Can you decide what?
Can you basically decide when or how much to represent a person, to the extent to which you can represent a person?
Yes.
So can you decide if you're just going to do the brief portion of the representation? Okay.
Yes. If I wasn't clear about that when I was talking about unbundled stuff, and people who are interested in that probably should read the limited scope representation rule first, but in case they want some extra confidence. But yeah, they could put sort of bright line borders around just exactly what it is they want to do to help.
Perfect. I think that clarifies things. And then one more question. Whenever you're approaching a clerk for guidance on, particularly on brief compliance, how do you go about making that approach? Do you email them? Do you call them? Do you go in person?
There's no wrong door. If you want to refer back to, this is for convenience sake of the attorney, if they want to just refer back to the briefing notice they received in the case, there's 3 email addresses on it, and they can email all 3 people. And I think our turnaround time, if we don't get, you know, the email at midnight on a Saturday or something, that aside, our turnaround time during the work week is lightning fast. They'll know very soon if they just email the 3 of us what's up with the brief, whether they get the green light to file or whether there's a few tweaks that need to be made before they can file with confidence.
And if representing an indigent Arkansan and you're thinking about filing an informal properties, when does that filing with the circuit court has to be done? At what point?
Yeah, I mean, it's not by a specific date. It's like you'd want to get it filed there so that there's enough time for that court to make a decision. I can just speak from observational experience that sometimes people will file them and they'll sit there without a decision. What you hope for is a decision, though, and it is until, I think that the take-home message here, to put a bow on it, is that up to and until a record gets filed here, even if it's a partial, up to and until that happens, try to get it done at the circuit court. If it looks like you're not going to get an order from it, then you can come here. But the appropriate place to go first is that circuit court. You asked about when you could do it. You can do it during the time of your 90 days. You could have done it before you even knew you were going to appeal. Maybe you did it already. So in terms of timing, I don't think there's a bright line date. It's when it comes up that it's going to be necessary. Like once you know you're going to appeal, like, oh, we were hoping we'd win this case, and we didn't. We now know we got to appeal. We know a record is going to cost money. The client doesn't have it. Go ahead and get to work on it.
Well, if anyone else has any questions, please let me know right now. I just wanted to, before letting everybody go, thank you for the time, and especially thank you for establishing such a wonderful program. I know that Arkansans are going to be very well served, and they're going to benefit from this fantastic program.
Yeah, thank you too for letting us talk.
Thank you. And I see no more questions. So everybody have a beautiful Friday. Enjoy the weekend.
All right, thank you.
Thank
Bye.
you, Chuck. Thanks, everyone.